In a significant order, the Supreme Court has ruled that recommendations made by the GST Council are, and I quote, persuasive and not binding on the centre or state governments. The court even ruled that states can frame their own GST legislations and rates. But do remember, we are still waiting for the final order copy of the Supreme Court. The Supreme Court bench, helmed by Justice Chandrachud, also said that the GST Council must ideally function in a harmonised manner and federal system needs harmonised work. The top court has also given relief to importers who've been fighting in various courts over the tax applicability on transportation of imported goods via the sea route. Pronouncing its order in the Mohit Minerals case, the Supreme Court has struck down IGST levy on ocean freight. This landmark order raises fundamental questions about the architecture of the GST. And to discuss the court ruling, joining us now is Mr. Thiagarajan, the Finance Minister of Tamil Nadu, T.S. Singh Deo, GST Council member representing the state of Chhattisgarh, Najib Shah, former CBIC chief, and Abhishek Rastogi, the partner at Khaitan & Co. He was also the lawyer of the petitioners in the ocean freight case. Gentlemen, appreciate you joining us here on the program. Abhishek, let me start by asking you, because you were representing the petitioners in this matter and you were in court when Justice Chandrachud read the operative parts of the order on this case, and more importantly, the implications of this order on the GST regime.
I think there will be huge implications. I think on the technical side, we were in the court for some very fundamental questions, such as what constitutes the recipient-based service and who's the recipient of the service, double taxation, extraterritorial and aspect theory. So I think that is more on the technical side, on the constitutionality of the levy per se, which were the moot points before the court. But I think more interestingly, the court had to answer certain points with respect to the powers of the GST Council, because those were the questions which were raised by the respondents, by the revenue, that these changes were implemented based on the recommendation of the GST Council. And hence, this question also became the part of the operative part of the order, because it was imperative for the court to decide that what role GST Council must play, should play in light of the Indian Constitution. And hence, Article 279 capital A of the Indian Constitution came into discussion to the fore, wherein Justice Chandrachud very categorically mentioned that Clause 4 of Article 279 capital A very categorically uses the word recommendation. It says that the GST Council must provide the recommendation. It also mentioned that various other parts of the Constitution also suggest that the GST Council must work in a harmonized way, must look into the harmonized system, and there must be emphasis always on cooperative federalism. And hence, as a corollary, there was a very specific finding that the decision of the GST Council will have a persuasive value. These will be treated as representations or recommendations, which the center and the state may or may not follow. So these are pure recommendations in nature.
Well, that's the important point, and that is the crucial issue that we will debate here with our guests. And as I pointed out, we are still awaiting the final order of the Supreme Court. The order copy is not available. Mr. Thiagarajan, I want to come to you now, because you have tweeted saying that this order is in line with your is in line with the comments that you had made to the GST Council on the 28th of May 2021, to the point being made there by Justice Chandrachud in his oral observations as he was reading out the operative parts of the order, as Abhishek just took us through that the powers of the GST Council are persuasive and not binding. But on the other hand, we've also seen that the GST Council has arrived at most decisions through consensus. In fact, the voting has only taken place on very, very few exceptional items. So on balance, Mr. Thiagarajan, what are the implications of this order for the GST framework as it enters year 5?
Well, first of all, Shireen, thank you for having me, and thanks for the question. Look, I would express my emotions first as shock and concern. Shock in the sense, unless we have all been suffering from collective blindness, what the Honorable Judge has said today is just basic kind of fact. right? If anybody operates in this system, you understand, once the GST Council makes some finding or recommendation or whatever, we have to each go back to our states and the union has to go back to the parliament and we have to legislate those changes into our respective laws. Only then it becomes legal. So the GST Council cannot reach into the Tamil Nadu legislature or the Chhattisgarh legislature, let alone the parliament. But what is shocking to me is that this collective slumber that this nation has been in for a while, or willful blindness, whether it is under what law was the RBI able to tell people in demonetization that the money is fungible in one shop but not another shop? Under what law was the RBI able to tell people how much money they could take out of their bank accounts? Under what law is electoral bonds valid? You know, all these things were effectively, we assumed that the nation was in some collective deep slumber or blindness, and so these issues would never get highlighted. So the first emotion to me is shock that the court says something that is as plain as day, that all of us are operating under every day, that in fact the GST Council has nothing but a recommendatory value and there is no legal binding to it. That comes as big news is shock to me. The second is concern, because right now we have a model that has been working because everybody agrees it works. Now somebody has told us, you know, there's not like a discipline or a constitutional requirement for it. Now what happens? Have we let the genie out of the bottle? And how are we going to deal with this? Those are the two things I would say upfront.
And that's what I want to address with Mr. Singhdeo as well, and I'll get you to delve a little deeper into that. Mr. Singhdeo, Mr. Tyagarajan's point is, look, he believes that this was a constitutional oddity in any case. That was his point of view. But you've been a member of the GST Council. The decisions, as I pointed out, for most part have been taken by consensus between the centre and various representatives of states. We've had voting on very, very few occasions on exceptional items, Mr. Singhdeo. Do you believe that this is now going to lead to an unraveling of the GST framework? Or is that too much to suggest?
Shirinji, first of all, thank you for having me on this show today with our guests. Greetings to you, greetings to all the panelists and all the viewers. For one, I'm very happy and very relieved by this judgment. Always never in favor of the right of states to be deprived of right to indirect taxes. So that was the biggest thing. Now, with this directive of the Supreme Court, I hope things are brought back into focus, and I hope the working goes to that level. There would be two aspects of taxation. One would be the rate of taxation. If you want a common rate of taxation throughout the country, I would have a little objection to that, because earlier we had tax havens where certain states were undercutting other states in taxation, and people were going there. I myself bought a vehicle from Goa, for example. My vehicle was registered in Goa just to test the rate of taxation. It was much lower there. So that is fine. But the right to the revenue of the state government, which it was enjoying through the VAT regime, that must not be taken away. So I am very happy and very relieved that the Supreme Court has taken a call on the very federal structure of this country. Now, if you see a couple of points that the Honorable Judge has enumerated, you mentioned about harmonious decisions or consensual decisions. Those were the initial days when Mr. Jaitley was the chairperson of the council. At that point in time, I remember quite well, and with a lot of pleasant surprise, that not one issue did he push through if even one state was not on board. There was no question of voting. His way of dealing with the situation was very mature and very equitable. And even if one state was showing disagreement, he would not allow a decision to be passed. Lately, though you mentioned that very few decisions have been taken through voting, the sense of the House is of a majoritarianism. It appears as if decisions have already been taken in advance, and those decisions have been brought into, as a formality, into the GST Council with the presumption that this is something that is to happen. This will happen. This will get passed. So that sense which has come into the GST Council of late that was extremely unhealthy. There was no scope for the federal nature of this constitution of this country to sustain. If you don't have right to resources, what is your independence? What is the federal nature of your polity? It vanishes. And the other thing, if you see the voting right, which the Supreme Court has also talked about, the 1/3 and 2/3. 1/3 lies with the center, 2/3 lies collectively with all the states. Now, if a decision is to be passed by a 75% vote, not one decision can be passed without the consent of the central government. So everything is in the court of the central government. If they want only, then it will happen. If they don't want, it will never happen. So the federal, so to say, constitutional independence of the states was completely abrogated by this GST regime. So whether it was during the UPA government's time or during the NDA government's time, I was never happy or comfortable, and I have always voiced my opinion on this, that the right to taxation, rate is another thing. Have a common rate throughout the country, I have no objection on that. But the right to taxation must lie with the state government. That was very clear. And as far as the dual layer, the Supreme Court has enumerated Article 246A, where both Parliament and the state legislature have the right to legislate on indirect taxes. So that is what Mr. Tyagarajan also mentioned. You cannot go beyond that. Then you're going beyond the Constitution, the provision of the Constitution. So I'm very happy and relieved on that count. And further, many a time the Supreme Court in this judgment, Justice D.Y. Chandrachud and the other members of the bench, they have enumerated things like dual layer federalism is known as a layer cake. Now, federalism of a multi-layer kind will become a marble cake. So see, the entire nature of the constitutional federal polity changes. When the constitution was read a whole, the union had been granted more powers. But the union and the state has simultaneous powers to legislate on GST. And the constitution does not envisage the repugnancy provision. So these are the things which have come out in today's judgment. And I, for one, and I hope there will be many, many, many such individuals in our country.
Najib Shah, former CBIC chief, let me come to you. You were at the helm when the GST regime rolled out, Mr. Shah. As you look at what has happened in the Supreme Court, what Justice Chandrachud has said, of course, laying down what Article 246A says, both Parliament and state legislatures have the equal power to legislate on matters of indirect taxation. What do you believe the implications are now for GST in its 5th year?
I do hope it's not going to unravel the GST regime, as it were, because much as has been emphasized by both the honorable ministers, the Supreme Court has stated the obvious, because the Constitution, when the constitutional amendment took place, it categorically was endorsed by all the states, and the GST Council's role was to recommend. And as told by the Honorable Minister of Tamil Nadu, both the Parliament and ensure that they endorse the recommendations and pass the necessary laws. Now, the critical question really is that, will this decision mean that each state will carve out its own path? I hope not, for the good of the country. I'm not getting into the issue of federal issues here. That's a larger issue which the Honorable Ministers have already addressed. I'm only talking from the point of view of a fiscal policy, of taxation, of our aim to have one nation, one tax for various reasons, which have been enumerated ad nauseum. The fact, again, like Honorable Minister of Chhattisgarh said, that it could go across to another state merely because of a tax advantage, which in turn led to multiple other issues of evasion, of tax loss and damage. So I only hope and pray that this decision will only help the GST Council in its functioning, will help the states in its functioning, and GST per se will not suffer, because too much of work has been done and we have come too far off for the GST itself to go away. It is here to stay, I hope, and we really need to improve upon it.
And that's what I want to address with Mr. Tyagarajan. Mr. Tyagarajan, you said that you're shocked and concerned about what you believe has been the collective slumber on the constitutionality of the GST Council's recommendations not being binding but only being persuasive, which has been upheld by the court today. But what happens now? Do you believe, as Mr. Shah is expressing, that we must ensure that we improve the system, but there should be no question of a rollback from the GST regime? What is it that you would now like to see happen from here on? One nation, one tax must remain, but there should be much more of a spirit of cooperative federalism within the council. What's the expectation that you have from here on?
Yeah, I mean, first let me clarify, Shireen, that when I say shock, it's a pleasant shock because it's a shock that we seem to be waking up, right? So it's not a negative shock. But look, in my initial, I wrote a long note. I think I've sent you a copy when I went to the GST Council the first time. And I pointed out so many limitations in it. I said partly because it was rushed to execution. It should have run on a trial or parallel basis. It should have had more time in planning. It should have had more kind of depth in structuring. But it is what it is. I am the finance minister of a state. It is extremely important to me that revenues come in at the right level from the right people. So I feel torn between kind of the philosophy and the execution. At the philosophy, I'm exactly in the same place as Honorable Minister Singhvi of Chhattisgarh, which is that, of course, the state should have some right of revenue generation based on their elected officers' understanding of their people's preferences. If all taxation effectively rides with the union, then, I mean, we are like municipalities. We get kind of the equivalent of property tax and some residual taxes and the rest of it go away. So at a philosophical level, I think one nation, one tax can be taken too far because all direct taxation effectively is with the union. Now all indirect taxation is effectively got a union veto or the need for the union's blessing before anything can happen. And states vary so much based on consumption patterns, based on per capita incomes, based on preferences. Why should taxation across, like, milk, for example, which is a very local consumption, be harmonized? In poor places, we may tax it less. In rich places, we may tax it more. These are all at a philosophical level. At a practical level, I hope that the GST Council Secretariat and the Honorable Union Finance Minister and my colleagues would agree that whatever my philosophical reservations with the system, I have been trying my best to get the system to work more effectively. And I still say what I said a year ago in May when I joined the council, that as many problems as there are with the philosophy or the design or the structure or all of those things, there are more problems in the execution. There are more problems in the attention. We are not putting collectively, the executive, the administration of all the states and the union, plus all our IS officers, etc., together. We are not putting enough of our time, effort, attention into this, and these systems are not being improved either at the right speed or to the right level at the right time. I can give you so many examples of GOMs being formed and being, inactive or becoming defunct or, all of these things, right? I don't want to embarrass anybody here. But I have raised this at GST Council meeting. I said, never mind, okay, I disagree in philosophy, but it is the law of the land. It is the way we get our revenue to run our system. Why can't we do this system better than it is? I may disagree that whether this is the right system or not, but this system can be done much, much better than it is today. Why is that not being done? I continue to feel that way. That's why my concern part comes in. It was not run that effectively or that efficiently first. This may cause new problems because it's certainly going to, set people thinking about different things.
Yeah, speaking of new problems, and Abhishek, I want to address that issue with you. Like the matter that we saw being taken up by the Supreme Court and the order being passed today in the ocean freight matter, do you see more such challenges now headed to various courts?
I think a very, very important question to be addressed at this stage, Shireen. I think I will divide the debate into two parts. One is wherever there are structural changes, the statutory changes, which are being implemented into the system today. The moot question today which arises, and I have challenged more than 200 such issues in different courts, the question which arises is that whether basis the recommendation of the GST Council, these changes could be implemented when these changes in itself are subject to judicial review. So the moot point for the first part of it is that whether the constitutional validity of such provisions will continue to be under test, even if there is a recommendation of the GST Council. And I think this decision, today's decision, provides 100% clarity on that in spite of the GST Council recommendation, today, either the state or the central government cannot implement something which is against the philosophy, which is against the objectives of GST, which is against the harmonized system and harmonized market for goods and services. So I think that is very clear. That part is very clear. The other part of the debate today is that what happens in a situation which are purely policy decisions. So some decisions such as the rates on casino, it may or may not be constitutional or unconstitutional. It will still be a policy decision. The recommendation of the GST Council will have a higher persuasive value, but state of Goa could have a different rate on casinos as compared to the rate in different states. So I think that will open the Pandora box for sure. I think so. We must divide the entire debate into two parts. One, with respect to those issues which require the test of constitutionality, and today's decision is very clear on that. They will have to cross the constitutional barrier or the test of constitutionality to in itself prove that these provisions are valid. Second, with respect to those issues where there may not be any test of constitutionality, but these are policy decisions, could states now differ, or the state could differ with the center, will remain a subject matter of debate.
Yeah, and let's address that second issue. Let's set aside the issue of constitutionality of decisions for a second, but let's address the policy decisions that you spoke of and your concern that it may open up the Pandora's box. For instance, you raised the issue of the GOM on online gaming, casinos, betting, and there's already been an outrage from the online gaming industry on GST rates possibly being hiked from 18% to 28%. And as you point out, maybe for a state like Goa, which could derive a large part of its revenue from casinos and the casino business, they might choose a different rate of taxation. Mr. Shah, does this now open up the Pandora's box, as Abhishek is pointing out, for states to go in different directions, basis their own considerations, their local considerations, their local factors?
It most certainly does. I mean, and that's precisely the point which I alluded to in my opening remarks, that I hope it doesn't, simply because it defeats the very purpose of why we are having GST in the first place. And without laboring too much on the need for a uniform taxation rate, it does make sense, I mean, to have a uniform rate. I do get the point made by the Honourable Minister that concerns for each state may be different, and hence there should be a possibility of having different rates of taxes. But then why have GST at all then? I mean, you go back to our pre-GST days of VAT and central excise and service tax, which for multiple reasons was not something which we wanted. We have been wanting GST for 10 long years. The empowered group of ministers had representations from all ministers, from all states, where all these issues were debated and discussed. The constitutional amendment went through a very thorough examination, where again it was agreed to by everybody. I mean, I was there. I can tell you it was agreed to by everybody. And you know, I only hope we improve upon it. We don't break this. We have some concerns. Concerns have been raised by the Honourable Minister.
Well, we will have to wait to see the fine print of the order delivered by Justice D.Y. Chandrachud in the Supreme Court today. Significant implications for the GST framework, for the GST architecture going forward. Mr. Tyagarajan, Mr. Singhdeo, Najib Shah, Abhishek Rastogi, always a pleasure. Many thanks for joining us here on this special conversation on CNBC TV18. We'll take a break here on Business 360. There's a lot more coming up. Don't go anywhere. We're back in a moment.